Okay. Hello, everyone. Hola, hola. Welcome to the Culinary Business Network presented by Feed the Soul Foundation, a place where you can connect, learn, and grow all at your fingertips. I'm your host, Karina Fernandez, Program Director of Feed the Soul Foundation. And today's session is a step-by-step I-9 compliance and ICE readiness. And I want to be very clear that this is not a fear-based training. It's actually all about being proactive and staying informed in the ever so evolving landscape of immigration enforcement. We're joined by a powerhouse of insight, attorney Saif Ali, who will walk us through real world steps on how to complete those Form I-9s, safeguarding our kitchens, food trucks, storefronts, and even our...
One of the main ways that you can safeguard yourself and mitigate risk is by completing the Form I-9, because that's how you're supposed to record your compliance with the law. And so sometimes I have managers, and when I give this conversation, when I have this conversation with businesses and associations, a lot of managers and business owners will say, well, how is this my job? What's my responsibility?
Mm-hmm.
And it's not just, if there's an ICE workplace inspection, it's not just your employees at risk. There's civil penalties and criminal penalties associated with this. And it's not just for employees, it's also for managers and owners. And everyone's liable really in the business.
Let's break it down section by section. So help us understand the first steps, right, as a business owner, and what steps they can take right now to reduce, those ICE audits or raids. We know that raids, okay, let's be honest, this is not going to get any better. It's probably going to get a little worse. And walk us through best practices on how to prepare, right, for those regular audits, and then how to really train our staff, especially our managers, to be compliant and proactive. So tell us a little bit about that that IRCA law, right? We'll start with I-9s, really understanding what is an I-9.
Right. So let's talk a little bit about what an I-9 is and what you need to be doing as a business owner. Essentially, if you don't have I-9s, you're probably one of the business owners that's most at risk, because not having I-9s is when Karina mentioned penalties, they range from approximately $300 to approximately $3,000. Well, the way that you limit your risk as a business owner and by maintaining compliance is by having I-9. So if you're missing an I-9 for one employee, you may get away with a smaller penalty and it'll be one violation. But if you don't have I-9s at all, then we're talking about maximum penalties, and we're talking about, liability, beyond civil liability, sometimes even criminal liability. So the first step is making sure you're doing I-9s for all your employees. Let's talk about Section 1. And the I-9 is a form that's essentially broken down into two major sections. And the first section is Section 1. And this is called the Employee Information and Attestations section. So this section is actually filled out by the employee. And before you do anything else, if you're setting up your I-9s, if you have I-9s already, but you're doing them for new hires, make sure you use the correct and most recent Form I-9. So the form is updated fairly regularly. But one of the first things that I want to talk about, and probably the main trip up that happens to employers with doing I-9s, is deadlines. So like any government form, there's deadlines involved. And the deadline for Section 1, and we'll talk a little bit about it later, but there's multiple deadlines involved in the I-9 stage. So we'll talk about deadlines for Section 1, deadlines for Section 2, deadlines for Supplement B, but right now, deadlines for Section 1. Section 1 filled out by the employee, and the deadline is the end of the first day of work for pay. Sometimes I have employers tell me, what does that mean? What first day of work for pay? So the first day of work for pay means that the first day that they're, if you're in a restaurant and you've hired a new line cook, the first day they show up and they're working and they're accruing their wages, that's the first day of work for pay. Now, if you have them come in for like a pre-interview and they just happen to tour your kitchen and they're not being paid for that, that's not a first day of work for pay. Your obligations don't begin on that day. But for Section 1, if they're showing up on Monday and that's their first day on the job, first day of work for pay, then the end of Monday is your deadline for completing Section 1. Now,
for them to complete Section 1, right?
For the employee to complete Section. And one of the things that I advise employers is that you don't have to wait till day 1, because things are hectic. You're in a moving, fluid environment. Employee shows up, you want to get them trained. There's so much that goes into day 1. And that's not something you want to leave to maybe, this could be something that we forget to complete by the end of their first day. So how early can you start Section 1? Well, the employee can start Section 1 after they accept a job offer. So that's the key thing. If you've offered the job, they can't complete I-9. But once you've offered the job and they've accepted it, then they can complete Section 1 of Form I-9. So the time frame for completion of Section 1, just to reiterate, is from when the employee accepts the job offer to when the end of the first day of work for pay. You're limiting the damage that can be done to your business. You're limiting the penalties and the fines, which is better than nothing. But maintaining compliance means following this deadline. And so for any new hires that you have, making sure that they follow the employee first day of work by the end of Monday, they're filling out Section 1. It's supremely important. So that way you limit the risk that you're exposing yourself to. Now, Section 1, because it's filled out by the employee, some of your employees may not speak English, or they may not be able to read or write in English. So a tip that we often give to employers is that Puerto Rico has Form I-9s that are issued in the Spanish language. Now, the key thing is that you have to, if the 50 states of the United States of America, you have to complete the English version of the I-9. But what you can do is give your Spanish-speaking employees a copy of the Puerto Rico I-9. And so what we tell employers, it's a great idea to laminate it, because that way the employee's not going to be tempted to fill out the Spanish version.
That's a good idea.
And that way they know it's clear. It's just a guide for them to follow along, but they still need to complete the English version of the I-9. And also, if they get assistance, if they get a preparer or translator to help them, then there's a supplement that goes along with this. It's called Supplement A, and it's important for that translator and or interpreter to prepare to sign their name on that form as well. It's just a small section where they indicate their details and they say, I helped and prepared and translate this form. Let's say you've been in business for 2 years and you weren't too aware of I-9s. One of the worst things you can do is backdate an I-9 when you didn't complete it on that day. If you're completing an I-9 now, it's important that when the employee fills out Section 1, they're filling out Section 1 on the date when they sign it at the very bottom. They're doing the date that the employee completes Section 1 and not the date of hire, because you don't want to backdate your I-9s. You want to complete them on the day you're completing them. And remember, late is better than never.
Got it.
So Section 2 can be completed by anybody that's an authorized representative of the employer. So anyone really it's kind of a wide range. It's anybody that you designate as the owner or the manager, is somebody that you designate with the authority to complete the I-9. So typically that's an owner, a manager, or an HR representative. But again, it can be anyone that you provide that authority to. So as long as they're an authorized representative. Now, the key deadline for Section 2 is completion within 3 business days, and you're going to have to bear with me, within 3 business days after the employee's first day of employment. So if that sounds a little bit confusing to you, you got to think of it this way. Let's say the employee's first day is on Monday, right? And they show up and they complete Section 1 before the end of Monday, and that's their first day of work for pay. What's 3 business days after that first day? So Tuesday would be the first day after. Wednesday would be day 2 after, and then the third day would be Thursday. So by end of day Thursday, 3 business days after the first day, which is Monday, you need to complete Section 2. That's your deadline. Now, business days is kind of a tricky word here. So this is why, lawyers live for this. We live for the trickiness. Business days is key because if you think of in a setting where you've got a, let's say an office, right? We're only open, for example, from Monday through Friday. On a customary basis. So for me, a business day is Monday through Friday. So if I hire somebody on a Friday, not that it's likely, but if I hire somebody on a Friday, well, then Saturday and Sunday typically aren't business days for me. But on the other hand, if you're a restaurant, chances are you're open on Saturday or you're open on
Mhm.
Sunday, and probably even open on both, right? So in that case, what happens if you hire a new cook, let's say on Friday? Well, then Friday is the first day of work for pay. They show up on Friday and they complete section one. Great. They've complied with the deadline for section one. You've complied with it. And remember, you're on the hook. So it's great that they're complying with the section one deadline. But then,
Right.
okay, so what's 3 business days after? So you're open Saturday. That's business day 1. You're open Sunday. That's business day 2. And then you're open Monday. So that's business day 3. So then at the end of the 3rd business day, Monday, you've got to complete section 2 of Form I-9. So remember, based on your business, based on your individual circumstances, this can vary. It really is based on what your business days are on a customary basis. 2 is physically examining the original documents, and the key word here is original, that prove the 2 main things that the I-9 is trying to verify. And the first thing is identity, and the second thing is work authorization. So the I-9 has an attached list of documents that are valid documents that the employee can show you. Now, one of the other key factors here, and I always like to stress this, it's the employee's choice to show you whichever combination of documents, provided that they're valid, that they want to. Now, if they show you an invalid combination of documents, you don't have to accept that. In fact, you shouldn't accept it.
It's
And one
kind
of
of
the
long.
questions you might have is that, how do I know that these documents are real? But you don't have to be a document expert. So the I-9 regulations don't require that you have to take a microscope out and really physically examine every single document with laser precision. But what you do have to do is look out for obvious signs of non-genuineness. So that might be something like a wrong background. So once you've completed the section, congratulations, you've completed the I-9. Now, your responsibilities don't end there. I know we're excited. We're like, oh, we're finally done. Well, not really, but you've filled out the meat and potatoes of the form. And we'll talk a little bit about now, okay, how long do you need to keep these I-9s? So for any employees that you have that are current, you need to be keeping your I-9s for them throughout their tenure at your company. Now, if an employee departs or they're terminated, you need to retain the I-9 for either the later of 3 years from the date of hire or 1 year after the date of termination. So it's important.
We've gone through every section of the I-9 that we are responsible for as business owners as well as the employees. Is there any other section that we should kind of be familiar with or understand?
So those are generally the main sections that once you've kind of familiarized yourself a little bit with the types of documents that you see and some of the documents that you might encounter. I think one thing that I did want to talk about a little bit was the List C document. This might be a situation that many of you come across. Is a really common List C document that you'll see is a Social Security card. It's probably the most common List C document of them all. If you're an employer, I imagine if you do I-9s, you've probably seen the driver's license and the social. That's a List B and a List C combo. But not all socials are good. And I wanted to kind of go over what's a good social and what's a bad social for I-9. So this, what's on the screen right now, that's a great example of a good social, because this is a Social Security card that's what we call unencumbered. It means that there's not any kind of restriction on it. Again, as long as it appears to be genuine and related to that person, that you can accept it as a valid List C document. But there are some Social Security cards that are what we call encumbered. And what they'll look like is that. And essentially, they'll have some variation of the language that says valid for work only with DHS authorization. And what that means is that this social was given pursuant to some kind of work visa. Maybe, for example, that person has an H-1B visa, or they've got an H-2A visa, or I think in the restaurant industry, you might see H-2B visas more commonly. If you have those kinds of work visas, you'll get issued a Social Security number because you got to fill out tax. The employees have to fill out taxes. They have to, for paperwork purposes, but they can actually use these socials just as an identifying document. So if I'm an employee, if I'm a new hire and I show up on my first day and I complete section 1, great, and I give you my driver's license and this social is not a valid List C document. So one thing that I wanted to touch on briefly is if somebody gives you documents that aren't valid, you need to let them know, hey, these documents aren't valid. A great thing, one thing that I advise doing is giving them a copy of the list of documents and just letting them know, hey, pick anything you want from this and
From
just
this
bring
list.
it to me. Remember, it's their choice what they want to do.
Florida is one of those states where you do have to use E-Verify at a certain amount of employees. And
Right.
then it is good practice to use E-Verify, but let's kind of break down what is E-Verify.
E-Verify, I know we talked about it a little bit, completing the form I-9s, right? E-Verify is not a requirement unless you live in certain states do mandate that you complete E-Verify. It's a system that works in concert with the I-9. So remember, E-Verify, if you're doing E-Verify, you're not absolved from doing I-9s. If you're an E-Verify participant, you're doing I-9s and you're doing E-Verify. And what E-Verify essentially is that unless you live in a state where it's not voluntary, it's a voluntary internet-based system that compares the information that's entered by an employer from the I-9 to records that are available to the Department of Homeland Security or to the Social Security Administration. And essentially the government confirms employment eligibility for you. And then there's something called E-Verify Plus, which allows you to actually complete the I-9s directly through E-Verify.
Right.
One of the biggest pros is that if you've ever done E-Verify, you know this, it's a quick system. It gives you a response within minutes of submitting an E-Verify case. And you can receive an initial determination pretty quickly. It also gives you a good faith defense because you're relying on a government system. So this is it's an added layer of protection. With an I-9, you're physically examining the documents, but remember, you're not a document expert. But the government is the document expert, right? They've got databases. So when you submit all that information on the E-Verify system, you can rely on it. And if the E-Verify tells you can rely on it, then you have a good faith defense. The employers say, well, look, I looked at the documents. They appeared legitimate to me when I completed the I-9. Right. I put them in the system and the system told me they were good. And then now you're coming back and saying, well, they're not good. Well, you know what? I did they looked reasonable to me. So they passed my test, the test that I'm responsible for, plus they passed the E-Verify system. So it gives you an added layer of protection. It's called a good faith defense that you can use if you're ever, audited or you face an investigation.
A little bit more about what we have on the screen right now.
So this is a situation where you might receive what's sometimes called a tentative non-confirmation. It's a mismatch. So like we talked about in a situation where maybe you've got documents that appear to be genuine, there are some really good fakes out there, really good fake documents that if you're just completing the I-9 and to any reasonable person, they may appear legitimate. But when the government has access to databases that you don't, and if it runs through the E-Verify system and it turns up as, hey, this document isn't valid, well, the government doesn't just send a buzzer and say, well, hey, you need to fire this person right away. That's not what they do. Typically, what will be the outcome of let's say a negative E-Verify result is that you'll receive this non-confirmation or a further action notice. And if you receive a further action notice, it'll essentially lay out the steps that you and the employee together need to take to resolve, and they'll give you a deadline. Making sure you're internally auditing your systems and making sure everything is shipshape. That's a great first step to take before ICE even shows up. But now let's say we're past that, ICE is at the door. What are we doing? Number one, always having a plan, right? The first thing that we should always do is if you have an attorney or you have legal counsel, notify them immediately and always have a designated manager to deal with ICE agents at once, because you don't want to leave it in the hands of, if maybe you've got a front of staff or a front of house, employee, maybe they're 18 or 19 years old, young, and they're terrified when an ICE agent shows up and starts flashing badges and providing documents, It's a good idea to have somebody that's trained and that's somebody that's been run through the procedures. It's often easier to train that one manager than it is you should train your whole team, but having that one designated point of response really gives you kind of a cohesive response, and it gives you one person who can be in charge of the situation and delegate and deal with things as needed. It's always a good idea to be calm and professional when you're dealing with government agents. So we say ICE, but sometimes there's corollary agencies that will pull up. Homeland Security Investigations, HSI is one of them. So, but you always want to make sure that it's it's a designated government, agency. And I hate to say it, that sometimes there are ICE impersonators out there. Right. It's always good to get verification that the agents are from ICE. Now, your manager kind of needs to triage the situation and see what they're dealing with. So ICE doesn't always, and we sometimes we talk about ICE raids, right? We say ICE raided this workplace, ICE raided that workplace, but ICE doesn't always raid workplaces. That's really kind of a drastic step of action. Their first line of investigation is what we call a notice of inspection. And that it won't look like a raid because there won't be ICE agents, coming in with, there won't be like 20 ICE agents coming to your restaurant and they might be armed, they might look scary. That's not what a notice of inspection looks like. It might be as simple as the ICE agent coming to your door, speaking with your manager, telling you that they're starting an investigation and serving you with a notice. If they're inspecting, they start a notice of inspection, they're basically inspecting whether you're following the law, whether you're complying with the I-9 regulations. And NOIs have procedures and tight deadlines. So when they provide you with the notice, it's going to tell you exactly what deadlines you're dealing with. Typically, you're provided 3 days to respond to an NOI. So if your manager gets presented with a warrant, if you've got legal on the line, it's a great idea to take a picture, send it to your attorney, or call your attorney and say, hey, I've got this warrant. Is this something that is this a judicial warrant? Do I have to let ICE in and search, my premises? Or is this an administrative warrant and where they're limited to they might be allowed to roam public areas, but they're not allowed to go into your private areas?
And speaking of that, one thing that I do want to stress is empowering not only yourself as a business owner, but your supervisors, your managers. Don't panic. Have a plan. That's what we're here to do. That mindset is everything. Conducting some of these like fire drills, right? Like mock scenarios, to also have your team really comfortable with something like this. We also have, you brought up something as well. There's tons of organizations right now kind of helping, differentiate between private spaces and, where the public can be. Now, we have had feedback of business owners where it depends on the agent and if they respect those spaces or not. And so as small business owners, how can we kind of, I don't want to say stand our ground, but really be proactive in, is it putting up these signs, or is it making sure that our managers are empowered to say, hey, you cannot go past this because it is a private space? Is that something that you all recommend?
Yeah. And so, for example, the signage that you have up there clearly delineating what are private spaces. Now, of course, not everything can be a private space, right? We have to kind of, if it's not obviously a private space, then just putting a private space sign on your restaurant floor where your patrons come and sit, that doesn't convert it into a private space, because generally that's open to the public to come in and sit. And without a judicial warrant, they are not supposed to be able to enter those spaces. Now, if they have a judicial warrant and you verify with legal that it's a judicial warrant, then you need to comply with the orders of that warrant.
Again, the staying calm, the know, which parts, they can and cannot go into, making sure that you do recognize the difference between a judicial warrant and an administrative. Contacting a lawyer. We have, you have at your fingertips, literally, Monty and Ramirez, their law firm. And then just continuing to staying up to date to any of those changes. We have a ton of resources for you all as well. Not only this one, but we also have employer rights and responsibilities from the American Immigration Council. And then we also have some more tips in terms of how do you, as a business owner, also protect your employees, right?
One of the products that we offer at our firm to anyone that's undocumented is the Plan Prepárate. And what the Plan Prepárate is essentially is an immigration defense strategy. So for one annual fee, we open a file for an individual that's undocumented, and we provide them with a letter of representation. We consult with them to establish an immigration defense strategy. If anything should happen, if they're taken into ICE custody, then we have a legal strategy set out for them. And then essentially what it does is the advantage the plan preparate offers you is that you've got immediate legal assistance at your fingertips. If you need us to file a motion, a bond motion, for example, if you're in ICE custody, or to work on some kind of relief from removal or deportation, then the plan preparate gives you the launching pad. We've got your file at the office. We've got we know your immigration history. We know the strategy that we want to pursue, and it saves you that time up front, because what you don't have to do is talk about all of this with an immigration attorney while you or a loved one is in ICE detention. Instead, you've got an attorney that knows all the facts, and you just say, hey, what we need is a bond motion, or what we need is a cancellation or removal, or whatever the strategy might be that we've discussed with you in advance.
Because it's federal and not like I can hire you all, or I can call you immediately if I need you all because I heard this, or
right. So immigration law and I-9 is part of the immigration law. It's a federal, it's federal enforcement. So of course, if you'd like to have an attorney that's nearby in your hometown or your home state, and you'd like to go through with them, that's completely, I think, perfect and something that you can do. But any law firm, including ours, that is practices immigration, and because it's a federal practice, we don't have to be in your state. We can represent you from. We're based in Houston, Texas, and we can represent you.
A quick recap: what we just talked about was ensuring that every employee has an I-9, and that you as an employee can fill those out with confidence and do it properly. We've considered even doing mock ICE drills, what to do if you do get a visit from ICE, and then also looking at E-Verify. And again, always stay calm, know your rights. We're giving you those resources. Don't act alone if that enforcement does happen. So you'll find all of this again in the resource library as a member. Again, if you're not a member, for less than $1 a day, you can become a member of the Culinary Business Network. And I was going to show the membership platform. Spreadsheets and templates will be available to our members on the Business Resource Library. We'd love to hear from you. Drop your questions in the chat, raise your hand. We can, have Saif reply to you all if you guys have questions, and you guys can obviously also reach out to them as a resource. So thank you again, Saif, for sharing not just, information, but a sense of clarity and control in an area that can feel very much so overwhelming. And to everyone here, the best way to protect yourself and your business is to be proactive. And your time today is a powerful investment into your people. And hopefully we can give you that peace of mind. And if, again, you haven't become a member, go ahead and check us out on our website. Our learning library is available as well. And remember, you don't have to do business alone, and you're not alone in this journey. And when you thrive, we all thrive. So see you all next time. Thank you so much, Saif.
Thank you for having me. Happy to help.
Yes, thank you so much.